Folks, we're going to allow just a couple more minutes for people to get online. At this point, it does appear that we have a quorum of the committee connected, but we'll just give them a couple more minutes to connect.
Somebody owes cookies for the committee.
I need everyone to mute your feed, please. All right, I think we'll get stuff going here. Committee, it appears we have, I don't know, 11 or 12 members. We'll keep checking the roll here in order to go ahead and get started. We'll call the meeting to order. I am going to grant leave to Scott Schultz with the Kansas Sentencing Commission to offer for introduction a series of bills through revisers, statutes, numbers, just to keep that process moving along. Scott will go ahead and offer those. And
thank you, Mr. Chairman. Can you hear me okay? Okay, these will all be 21 RS numbers. The first is 438. This is to expand the drug grid presumptive probation. The next is 437, changing certain penalties of drug crimes. The next is 14, codifying the definition of absconder in statute to assist probation and parole officers. The next is 264, allowing earned discharge credit for people on probation and maximum probation lengths. The next is 263. It has to do with special sentencing rule number 26 and determining prior convictions when charging crimes in the same complaint, as well as clarifying concurrent and consecutive sentencing for persons convicted of new crimes while on release for a felony. The sixth is...
Yeah, we have a bit of a technical glitch. I'm going to have to ask you to go back to the beginning. You were not feeding any audio with your introductions here, please.
I'm sorry, Mr. Chairman. You want me to go ahead and start over?
I would think about Genesis 1. Yes, I would go to number 1.
Just the 263?
Right from the very beginning, we heard nothing of what you had said.
Okay, and you can hear me okay right now?
Yes.
Okay. Again, all of these will be 21 RS numbers. The first is 438, expanding the drug grid presumptive probation. The second is 437, changing certain penalties for drug crimes. The next is 14, codifying the definition of absconder in statute to assist probation and parole officers. The next is 264, allowing earned discharge credit for people on probation and maximum probation lengths. The next is 263. This has to do with special sentencing rule number 26 in determining prior convictions when charging drug crimes in the same complaint and clarifying concurrent and consecutive sentences for persons convicted of new crimes while on release for a felony. The next is 57, requiring legislative members of the Sentencing Commission to be members of the Senate Judiciary and House Corrections and Juvenile Justice Committees. The next is 190, clarifying jurisdiction and supervision for offenders in a certified drug abuse treatment program. The next is 439, early prison release to community corrections for certain drug offenders after 50% service of sentence in DOC. The last, or the ninth one, is 436. That would be amending the requirements for offender registration. And that is what on behalf of the Sentencing Commission, we have.
We again had a bit of a glitch in the middle. I will tell you the numbers that I have written down that I heard you speak, and would ask that those that are not listed that you repeat those. I have number 438, 437, 414, 459, 190, 439, and 436. Could you repeat those that I have not listed?
Yes, I believe I have 14 rather than I think you had 414. I also had 264, 263, and 57.
And the general titles for 264, 263, and 57?
264, allowed earned discharge credit for people on probation and maximum probation lengths. 263, determining prior convictions when charging drug crimes in the same complaint. And 57, requiring legislative members of the Sentencing Commission to be members of the Senate Judiciary and House Corrections and Juvenile Justice Committees.
Thank you, Scott. Committee, and particularly for our new members, introduction of bills in this matter is fairly customary and seldom any objection to these. Scott Schultz, on behalf of the Kansas Sentencing Commission, has offered RS numbers 438, 437, 14, 457, 190, 439, 436, 264, 263, and 57. And without objection, those will be accepted, and the process will begin with those bills. Are there any objections? I see no objections. They'll be accepted. Mr. Schultz, thank you. And committee, we will proceed now with the presentation by Scott Schultz on behalf of the Kansas Sentencing Commission. I'm going to ask committee members to hold questions until the end of this presentation.
Well, thank you, Mr. Chair and members of the committee. I'm very pleased to be with you on behalf of the 17-member Sentencing Commission. We do this for those of you that are newbies. We do this every year, and we certainly appreciate the opportunity to come and speak with you. The title of my presentation pretty much covers the agenda that we're going to cover this afternoon, to talk a little bit about what's going on as far as data in the criminal justice system. The Sentencing Commission is the state statistical analysis center for criminal justice, and so we have an opportunity to get a lot of sources from KBI, from DOC, from many different, as well as gather data ourselves, so that you can have a better idea and be able to better make policy-making decisions during this legislative session. And so I'm going to go ahead and share my screen. Can you see that?
Looks good.
Okay, thank you. As many of you are aware, we do have a 17-member commission that is composed essentially of a cross-section of the criminal justice community. That extends from our legislative membership of two representatives, Representative Heiberger, of which obviously is on this committee, who is a fantastic member on our commission. Representative Barker is also has great input for us. We have two senators that participate, the Secretary of Corrections, Prisoner Review Board Chair, and then Attorney General's representative, as well as various judges and probation personnel. We do have several public members, and probation, including community corrections and court services, are represented. So we have pretty much everybody at the table. And what you're going to see as far as later on in the presentation proposals will give you an idea of this group that has come together. As we always do in September, we have a workshop, and then we are able to give you proposals that we believe are in the best interest of the sentencing guidelines, as well as the criminal justice system as a whole. So we obviously can't do that without them. The primary duties of the commission, I'm just going to list a few of those. We have 20-some statutory duties, but really our business is cyclical. This time of year, we are looking at mainly legislative bed space impacts, and that's one of the things that you will be receiving on a regular basis for those of you who are new to the committee, that will specifically have on each bill items that will tell you our best estimate as to what, based upon the language of the bill, what you are going to what kind of bed space you're looking at. So we do that on every single criminal bill, and you will get that when it comes through your committee. House Judiciary, we do a little bit of too, depending on the bills that come through there. As I mentioned before, we are the State Statistical Analysis Center for Criminal Justice. We maintain 14 different databases for criminal justice. Again, that becomes from databases that we maintain, those databases that are relevant from DOC, KBI. We have, as far as like KBI, we have 1.8 million records from them dating clear back to 1912. So that gives us some arrest data, conviction data, sentencing data, and then we also collect sentencing data as part of every felony that is committed in the state. A journal entry is completed and sent to us, and then we're able to, that document is not only does it memorialize what happened to that offender on that particular day, but it also is a data collection instrument that allows us to place all of those items in the database, that then allows us later on to bring information to you for these bed space impacts. So in addition to that, we provide educational outreach. One of the main things that we do is the desk reference manual. Some of you may have seen that before. On an annual basis, we put out a desk reference manual that goes over all of the sentencing ins and outs of sentencing for practitioners. And then, of course, in the summer, once DOC has cut their data, we are required within 6 weeks to turn around a prison bed space population projection for them. And then that is released usually in August or so. But the annual report is another item that I'll be sharing with you in just a moment, the results of those. We usually put those out in April. One of the other programs, in addition to our normal operations that I've talked with you about, is the Senate Bill 123 program This was passed in 2003 that allows for substance abuse treatment for certain offenders that are convicted of possession crimes. So if you're convicted of possession of meth and you fall into the criteria, you then are allowed to be supervised by community corrections probation, and it becomes state paid substance abuse treatment. This program has been in effect for, as I indicated, since 2003, and has been very successful in assisting communities with helping those offenders to get out of the revolving door of coming to prison. And so that is that comprises it's a pass-through type of situation, but that comprises over 90% of our budget that we pay to over 140 treatment providers that are certified with us throughout the state. And so that they provide treatment, and then we actually act as the bank to administer and pay them. We also have private research requests. Because we have very good data, we do get academic requests on a regular basis from universities all over the country. We do charge for that. We have a $150 an hour research fee that we charge, and that actually allows us, since we are primarily SGF funded, to have some revenues from that. It's not very much, but certainly for that particular data, it is well worth the money that they're actually getting in their data. The other revenue source is the reference manuals that we sell to practitioners. Usually about 900 of those is what we print every year. We also have a Q&A helpline. I have a part-time staff attorney that
Okay. It's not working.
Are you still able to hear me? I'm sorry.
Yes.
Okay. We also have the Q&A helpline, and that allows me to have a staff attorney available to probation, to judges, to attorneys when they run into sentencing issues. And so that is, we usually handle somewhere in the neighborhood of about 300 contacts every year with individuals seeking assistance on how to apply the guidelines. Now, certainly, we obviously can't tell them, and we aren't a primary source, but we point them in the right direction because, thankfully, and I'm very grateful, we have a staff attorney that does a very good job in being able to provide case law as well as other counsel to them to get them headed in the right direction. We currently have 14 team members that I supervise as executive director of the Sentencing Commission. I've included down here some of the things that I've already kind of talked about as far as we are research-based. We also handle, I have a master's level psychologist that handles the Senate Bill 123. She is the director of that and handles the administration of that. And then we have legislative issues that we've talked about, as well as those legal issues when the journal entries that I spoke about, as well as the pre-sentence investigation report. All of those are, the Sentencing Commission is required to maintain those. So on an annual basis, we have a specific journal entry forms committee that we set up that we make any changes based upon what the legislature has done the previous year, or if there's any case law that's come down from the appellate courts, we then modify the journal entries to reflect those changes so that everybody filling those out, which they're then required by every jurisdiction in the state to complete those journal entries. And that is the document, again, that I indicated that memorializes what happened at sentencing to that offender on that particular date. Just a little bit of history on the Sentencing Commission. There were prison overcrowding issues back in 1988. A court order actually came down that required reduction of the prison population. and the Criminal Justice Coordinating Council recommended that a sentencing commission be established in 1989. They were, and as a result of that, in 1993, the Kansas Sentencing Guidelines Act was passed. This was primarily done because, and this was a movement that was actually going on across the nation as well as going to a sentencing guidelines, mainly based upon those last three bullets that you see on the screen right now. There were disparities that that everyone was seeing in the state based upon geography and race. You had situations where individual judges in Shawnee County could see 10 or 15 burglaries on their docket in an afternoon, whereas a judge in Kearney County, for example, may only see a burglary once every week or once every couple weeks. So that sentencing, there was when there was an indeterminate sentencing scheme, we were seeing wild fluctuations of sentences that were being handed out by the courts. Race was obviously also another item that needed to be taken under consideration, just simply because of the population centers and where minorities were actually located. The sentencing guidelines provides for two grids that do not discriminate with regard to race. And so it also provides for proportionality in sentencing, as well as truth in sentencing, because as we'll look at here in a couple slides, there is a grid, and you can definitely see, based upon the severity of the offense and your criminal history, just exactly how many months that you potentially could serve in an incarcerated capacity. So it provided all parties, not only the offender and the courts, but also the victims, to know that what an individual potentially could be sentenced to. So the main mission of the Sentencing Commission is what I normally call is the commission is the gatekeepers of the guidelines. And our job is to help in maintaining those guidelines, as well as providing the legislature and the governor's office with new ideas, new recommendations, new suggestions to maintain those, but also to enhance them based upon the data that we have. And so the guidelines were originally set up to make sure that presumptive sentences or presumptive prison sentences, that incarceration was reserved for the most serious offenders, and that primary purpose was for incapacitation and punishment. As the years have gone on, we've moved to rehabilitation, because we've understood some of the data better, to know that 98 or around 98% of those offenders that are incarcerated will be released at some point in time, and we have to make sure that on that reentry process that they are receiving vocational training, as well as what they need to keep from settling back into the same habits that they had before they were convicted and sentenced. So we have presumptive guidelines, and you'll see as far as the sentencing guidelines grids are concerned, there are presumptive prison, presumptive probation, and then there are border boxes in which the court can, it's a presumptive prison, but they can sentence the individual to probation or prison. Why do we have these guidelines? These 3 points kind of cover it attempts as best it can, as we said before, race and geography where there was disparity there, and it attempts to establish equity among offenders in those typical cases. It also allows for discretion for the courts in atypical cases, so that they actually can depart from those sentences if they meet the standard, substantial and compelling. If there's substantial and compelling reasons, they can actually depart from that. So it does provide for discretion on some of the cases that may be particularly heinous, that are out of the norm, that may be in an aggravated and they may need a higher sentence, or there are mitigating factors that they utilize to sentence them to a lesser sentence. Finally, from a data collection standpoint, and in terms of our office, it certainly allows for more certainty in predicting prison populations. In an indeterminate capacity, it's very difficult to be able to estimate and predict those populations. When you have sentencing guidelines, it provides a structure for us then to be able to estimate, but also then see where everybody is falling within those grid blocks. So it certainly makes it easier, which then allows for better predicting for DOC and others that are looking at the prison population. Annually, we review legislative and administrative changes from the legislature as well as the governor. We track all the relevant bills, all of the criminal bills. About half my office during this time of year are actually working on legislative items, and certainly it takes that many to process all of these in terms of looking at certain bed space impact. We utilize our databases then to be able to bring you the bed space that you see on the impacts. So the next two slides are just simply there's a non-drug grid and a drug grid, and these have been promulgated since the inception of the guidelines in 1993. Non-drug offenses, as you can see across the top, are based upon criminal history, and then vertically, the severity level 1 being the most severe, so severity level 10, the least serious. And then you can see, based upon your criminal history and the severity of the particular crime you've been convicted of, what kind of monthly sentence you potentially could receive. So the white areas are presumptive prison, the yellow or the green areas are presumptive probation, and then the border boxes, as I indicated, are what are called presumptive imprisonment boxes or border boxes, and that allows the court to go either way as far as sentencing the individual to prison or probation. The drug grid is smaller. It only has 5 levels. We'll be talking about this probably a lot this session. So getting used to these are level 1s through 4s are sales, distribution, manufacturers are level 1s, and then all of your level 5s would be possession crimes for possession of heroin, meth, cocaine, and in some cases marijuana as well. So just keep that in mind. From greatest to least serious is what you have on the drug grid. We have an annual report, as I indicated, every year. This is, again, we're a little behind just simply because this is normally in April is when we would put out the next annual report, so that'll be coming up in a couple months, but this is the most recent. I thought it would be helpful for you to kind of give you an idea of what we see as far as top offenses, what the breakdown as far as race and gender is concerned, just to give you an idea of the cross-section of the felons. And keep in mind, these are only felonies that we deal with, but also those are the most serious of the crimes. So as you can see on the slide, the top 5 offenses that we see, drugs lead the way by a large margin. And that has been consistent for many years. We have property crimes such as theft and burglary, as well as DUI sneaks its way in there as well. And then keep in mind, this is felony DUI, folks that have had multiple DUIs. And so it's made its way into the top 5 as well. One of the situations that we've seen, and it continues to be consistent, is distribution of race among offenders. Thankfully, again, with the journal entries and the data that we have, we're able to pull out and utilize, slice and dice about any way we want and the way you want to be able to determine different demographics as far as race and gender and ethnicity and those type of things, age of the offenders, so that we can get a better picture of who the folks are committing crimes. And what you'll see is, as we see in this particular slide, the distribution as far as race is our African American population is almost 21%. According to the 2019 U.S. Census Bureau information, Black population in Kansas makes up about 6.1%. So the African American population is well overrepresented as far as our sentences are concerned, and that stretches not only to probation but also the incarcerated population. As it relates to gender, this has pretty much stayed consistent in terms of about almost 8 out of 10 of the offenders are male, and that's one of the rationales why we only have one prison here in Topeka that houses females, just due to the population. As it relates to ethnicity, you can see the breakdown as far as non-Hispanic versus Hispanic. Distribution of the age of offenders, that was something I just talked about. What we see is normally the overall population will max out usually in the 25 to 30 range. We have a lot of offenders that that have felony DUIs, and it obviously takes a little while to get to that point where you've had multiple DUIs, and I think that pushes up our age population a little bit. This particular chart is very consistent with national trends in terms of, you see that as folks in their early 20s and 30s are committing most of the crimes, as we get older and wiser, that the number of those starts to decrease, and as offenders mature, there's a drop off after 41 that you see here. That's again very consistent nationally, that with age groups. In FY19, we did have a decrease in admissions. We'll talk about this last year as well, which was a significant decrease in population. That was kind of the trend for a while. Obviously, this last year is a major anomaly. So we're not going to continue to rely on that, but just to show you, it was actually decreasing as far as our population prior to that. Again, males make up predominantly are the predominant offender group, making up almost 83% of the offenders admitted to prison. And then you can see the breakdown as far as white and black and other races as far as their admissions. One of the things that has been talked about before is that Kansas is a state where many of the offenders receive probation and are not sentenced to prison. And so we've actually seen, as in this particular slide in FY19, we did see that probation sentences have increased. And keep in mind, with the increase, that obviously increases caseloads for probation officers, either with court services or community corrections. So that always needs to be a consideration, certainly from a budget standpoint. But that is one of the things that we can tell you with data that their caseloads are increasing based upon the increase in sentences to probation. This is just a breakdown again of what that breakdown between non-drug and drug sentences are. The next one is a top 10 of probation non-drug sentences. The theft and burglary, as well as aggravated battery, lead the way. There are also some other person felonies like criminal threat. Then we also have other non-person crimes like forgery that make up the top 10 as well. But that just kind of gives you an idea of the main crimes that you're going to see statewide. When we break down probation drug sentences by offense, almost 8 out of 10 are possession offenses. We have most of the drug crimes that you'll see are small sales or possession. We don't have a lot of, in comparison, a lot of major dope convictions. A lot of those will go federal, but some of them will be pled down. But the highest percentages that we see as far as drug offenses are in that small sale or level 4 or to possession level 5 crimes. We also track crimes that are called non-grid offenses that are not on the grid. These are crimes that, such as felony DUI, felony animal cruelty, and then felony domestic battery, they're basically self-contained crimes that are self-contained within the statute. And that not only is it the elements of the offense, but it also gives you the penalties as well. And so we track this outside. None of these crimes are sent to prison. These are all crimes that are served in the county jail. It gives you an idea of how much of that DUI encompasses almost is 88.9% of the sentences. I'm sorry, it's actually 97.3% of those sentences, followed by domestic battery, which was 13 sentences, and then 1 sentence for animal cruelty. Johnson County normally leads the felony DUIs, and then Sedgwick County. Normally, some of that can be attributed to cross-border folks crossing over from Missouri and coming into the state. But normally that is one of their top 4 crimes every year is felony DUI. We also are able to break down sentencing trends as it relates to the counties. And as you can see, the big 4 pretty much comprise almost half of all felony crime in the state. Sedgwick County, essentially 1 out of every 5 felonies that's committed in our state is done in Sedgwick County. Johnson County, Wyandotte, and Shawnee then follow. Again, this is fairly consistent throughout the years, and the rest of the counties then follow after that. So in July, we are, once the fiscal year is over, DOC cuts their data that they've had from the previous year, and they send it to us. We have 6 weeks to actually put that together. We have a couple consensus meetings that are made of folks that are similar in cross-section to the Sentencing Commission that look at potential assumptions to be made in the projections, but we look at what the previous year looked like in order to give DOC as well as you a 10-year projection on what we believe the prison population will look like going forward. Again, there are assumptions made. The two main drivers of prison population is admissions and length of sentence. Pretty much makes sense, right? If you have less of one or more of one or more of both or less of both, then that's going to dictate what we're going to see in the future. We also, as a secondary measure, we're also calculating things like jail credits, program credits, good time credits that are baked into the system in our computer model to allow us to actually follow an offender from the time they go into the system until they actually get out of the system. And so in doing that, the computer model does this obviously over thousands and thousands of times to track offenders, and then it gives us an idea of an estimate of what we're looking at. So one of the things that we were looking at this past year was something that, of course, the pandemic has caused unprecedented situations in our system, and this is obviously not the first time you've heard that. But with regard to prison populations, it had a significant effect. And so you can see in fiscal year 2020, we saw a dramatic drop in total prison population. We also measure admissions versus releases, because normally if you have more releases than admissions, your population is going to go down. Here, obviously significant decreases in admissions. The courts closed down for a period of time. We've had starts and stops and not too many starts as far as jury trials are concerned. So there are a lot of jurisdictions that have not jumped back into that yet. There were many things that were delaying the process. Most of the jury trials certainly are going to be individuals with more serious offenses that probably are going to be sentenced to prison. And so those folks were staying in jails while everyone was actually awaiting the time when we could actually have jury trials. And so that, as a part of that particular time period, there weren't jury trials happening. So there weren't folks from that part of it being admitted to DOC. I will say, as far as the question, of course, comes in, then why were there being releases too? DOC actually had put things in place prior to this that they were actually working very hard on reentry and getting folks to be released. And so the releases, regardless of the pandemic, would have probably been down, maybe not as far, but would have been down because of the actions that DOC has actually been implementing. We look at things as far as how people get to prison. One of the things that is the direct new court commitments. What that means is I go to court, the court sentences me directly into the custody of the Secretary of Corrections. At that particular time, I go back to my jail cell and wait for DOC to come pick me up. These are how we measure these new court commitments. They obviously, of course, dropped off significantly due to COVID. The others certainly are your sentence to probation, and you get out and you're supervised by a probation officer. This allows for individuals to comply or not comply in many cases with their terms and conditions of their supervision. And this slide reflects the numbers of condition violators that were then revoked and then sent to prison. And so again, we've actually been seeing a decrease or a downward trend even since 2018 here. and but certainly very much more significant during there weren't as many probation condition violators. Some of that had to do certainly with just simply you didn't have probation offices that were open to seeing clientele, and so if you can't check for hot UAs and things like that, your numbers are probably going to be a little bit less than what they would have been had they been in a normal supervision type of capacity. So, but as I said, that's continuing. That's actually a continuing trend, though, from 2018. On the back side, we talk about the direct commits and the probation revocations as the front door of the prison. The back door, when people can come in the back door, is when they've already served their sentence and now they're placed on parole or post-release supervision. There are parole officers then that supervise those individuals, and this slide represents those folks that actually violate the conditions of their parole or post-release and are sent back to prison. And so these are the admissions that, again, we had quite a few, quite a drop in of 200 actually in 300, 200 that was significant due to the pandemic. This just gives you a comparison of both of those that we already talked about as far as the violators with new sentence, as well as the parole post-release violators with a new sentence. And that basically means that they actually received a new conviction during the time they were on supervision. So once we actually take that information from DOC, the consensus groups look at potential assumptions on where we think that things are going to be going. This particular year was absolutely wrenching. I was so grateful that we had the research staff that we have that have been through. My director has been with us now for 25 years and has seen almost everything, not quite this, but we in the previous years have done things like we've split populations as far as gender is concerned. This year we normally will have because it's normally an increase in population. This year we had to look at it in terms of what was potentially going to happen between now and the end of the next fiscal year, and were the courts going to open back up? Were they going to allow for jury trials? There were a lot of different variables that we've had to actually include because that we haven't had to before. And so this made the projections even more difficult than they normally are. What you see here on this slide is the projection. And just to kind of explain a little bit, the 2020 numbers are the actual numbers. The rest of these numbers are the projected numbers. And then at the end of the column, on the right-hand column, is the percentage of change. So, for example, we are predicting a 4.3% increase in prison population, total population, by the end of 2030. We break these down by offender groups, and these are similar groups that the DOC looks at. But these these normally are increasing by quite a bit based upon what we saw the past year. We were forced to do a little bit more calculations, and so we are looking at potentially about 395 extra inmates going into the 2030 or ending 2030 fiscal year. I always tell people that certainly the Sentencing Commission does not have a crystal ball by any means, but the data that we have and the computer model has been unbelievably accurate the last several decades. And so we continue to utilize that model in hopes to help you make good decisions as far as, in situations like this where it's down, that's good news. That certainly is good news instead of having double-digit increases between now and the 10-year projection window. This also helps at some point for DOC to make determinations of whether they actually need to build or not. And so this is mainly why we do the prison population projections, is for DOC's use and for the legislature to be able to see what we believe is coming up as far as estimating the population. So put into graphic form from that table, this is a representation of what the actual population is through the present time, and then what we believe going forward the population is going to look like. Keep in mind our total capacity is 10,368. That's male and female. As you know, since we have about 88 to 90%, or anywhere from 88 to 92, 93% are males. That table looks, of course, similar to what you would see with just a male population. Again, capacity of 9,420, which puts us well under based upon the decline that we had this past year. The female population had been riding at capacity for several years, and with the pandemic, it is bumped down below 7 or below 800, and so it actually is riding under that capacity of 948. So like any good agency, one of the things that we do is we make sure that we track our metrics that we're working on. And one of those key performance indicators is how close, when we project, do we get to the actual population. These next tables will actually show you on a monthly basis what the model looked like for the 2020 model, what we projected in this particular column, in the second column, to what the actual population was. And you can see we usually, normally in statistical speak, 5% on either side is good. I make my folks get us down to 2% or under. And that's what our goal is to be able to make sure that we're getting as good in numbers and that the model is as good as it should be. So you can see here, we were within a little over 0.1% in July of error, and we looked good all until the pandemic came and visited us, and then the bottom fell out. Certainly, this was something that was not in the projections, so that actually is something that was not planned for. But up until that point, certainly. The model was working very, very well. These next two slides just break up the male and female population to give you an idea of what the differences are. Certainly, again, April, May, and June told us different as far as numbers continued to actually decline at a significant rate. So at the very least, thankfully, we were overestimating rather underestimating. Female population, just because it's a smaller population, certainly any difference in numbers is going to be a wider swing as far as percentage. And so you can see that we almost got up to 21% with the June population, which translated to 164. Thankfully, though, again, it was on the other side, so that there was some space that was being then allowed for in Topeka Correctional Facility. So how are we doing now? This gives you an idea for this fiscal year what the 2021 model is giving us so far. again, this was something that we were looking at negative growth for a period of time, flattening out, and then starting to increase again. And so that's something that, of course, we haven't had to deal with as far as our projections are concerned. But what the consensus group was seeing was that we continued to decline in population month over month. So, so what you have here is, so far, we are certainly within that 2% as far as total population. Just to give you an idea graphically, this is what we projected on the blue line. Here's where we are as far as actual. We had previously estimated that we would wait till this particular month before we would start increasing again, but it looks like we're about a month behind. And so we'll continue to monitor that. One of the things that we've talked about is possibly, depending on the circumstances, we are going to revisit this in the next month or two to see how the model is still working, where the numbers are at. But as of right now, it still is looking pretty good. Again, this just is a breakdown for male, and the next is female as far as where we are. Again, the model is working. We're keeping within those ratios, and I'm very pleased with where we're at, specifically because of the uncertainty. And this just goes to show that once again, and I of course am biased, but the model and the personnel that we have to actually administer the model has been nothing short of outstanding, to be able to keep us on track to make sure that these estimates are as close as they can to actual. So we have, as a result of our charge of being gatekeepers of the guidelines, we are asked to make recommendations to the legislature and the governor's office every year as to how we could, what we can do better as far as maintaining the guidelines, and what other new things are out there that that can be shown to be hopefully successful in Kansas. So what you will see in the next slides are some of the initiatives that what you're going to see this year is a convergence of several agencies that have joint recommendations. We've worked with the Reform Commission, Criminal Justice Reform Commission. We've worked with the Judicial Council as well to bring together some recommendations to you that I'm very excited about. They're very progressive, and what I would say is, if you have anything to take away from my presentation, my hope is that you will see that we have an opportunity moment this year, an opportunity moment that allows us, because our prison population is essentially in the low 80s as far as capacity is concerned. We really have an opportunity to tamp down and keep it at that level, so that we don't have to continue to always worry about overcrowding, overcapacity situations. Where are we going to put the next inmate that's being admitted? So these particular proposals, as well as ones from the Reform Commissions, the ones you'll see from Judicial Council, the ones you'll see from Judicial Branch, are all designed to accomplish those tasks. And I certainly, like I said, I'm very excited because there has been a lot of work the last year, the last 2 years in bringing these initiatives to you. And we've even pulled in, as many of you know, the Council for State Governments, who do technical assistance for states all over the country. We've taken recommendations from them, adopted many of those recommendations as well. And so I'm just going to get into it. I'll quit talking here about that and just jump into it. One of the things that is very popular right now is incentivizing offenders so that they will successfully complete those things that we require of them while they're on supervision. This first one has received broad consensus in terms of allowing for incentivizing not only offenders but also prosecutors to actually have a robust diversion program for possession offenders and of controlled substances. There are certain jurisdictions that have been doing that for several years now with success. This would actually allow for those prosecutors to divert simple possession offenders from the system, but also, which is a benefit for the offender certainly, to keep from getting a felony conviction or those type of things, but it also would then provide SB 123-like or state-paid treatment for substance abuse, the substance abuse treatment that they need. That is, again, this is a joint recommendation from the Sentencing Commission with the Reform Commission. It's been pre-filed already as House Bill 2026. Same measure that passed out of the House last year, 125-0. Again, we have a specific crime, unlawful tampering with electronic equipment, that we have also another joint recommendation with the Reform Commission. It's been pre-filed and now as House Bill 2027. This is something that the House Corrections has already passed out. This has been around for a while, but it is a proportionality bill that takes the current penalty of severity level 6 down to an 8, which is more proportional with that of escape from custody, for example. If it's a misdemeanor that they're on supervision for, this is something that you'd be wearing an electronic monitor, an ankle monitor or something for. If you're out on supervision, for example, and you cut it off, this would be that violation of tampering with the equipment. If you're on misdemeanor supervision and you do that, it would be a Class A misdemeanor. If you're on for supervision for a felony, it would be that severity level 8 felony. This is also been filed as House Bill 2028. It's a joint recommendation with the Reform Commission that they are also encouraging this body to pass it. It increases, we have theft already has a $1,500 threshold. Mistreatment of a defendant adult back in 2018 was also passed, and the threshold was increased from $1,000 to $1,500. This would simply bring up all those other tiered property crimes, which number 11 in number to $1,500. Obviously, what you're seeing on the right-hand side here are bed space impacts that we again would be providing. Not too much impact here, but again, this is more of a proportionality bill that would, and this again was something that has been passed out by House Corrections. One of the things that Representative Heiberger has pushed, and the commission joins him in that recommendation, is to establish a more robust compassionate release policy from the Department of Corrections. The current eligibility is 30 days in which you would potentially be dead. Physicians have to certify that. This would actually increase that. Your current conditions would likely cause death within 120 days rather than 30. This arose from the fact that we were held out in articles as possibly the most stringent in the entire country when it comes to this, and they didn't actually see any, very few folks actually being released because it took about 30 days for the paperwork to actually be completed. And so people actually literally weren't making it out alive to be released. There has to be a release plan. There is criteria that is set out in statute. So we aren't just releasing people that that may have maybe eligible. There are certain criteria that DOC is that are already in place that they're looking at public safety certainly for before release for these folks. So again, this is a measure that was passed out 120-5 by the House, and it's currently been pre-filed and is currently now House Bill 2030. When offenders are in prison, depending on the severity level of their crimes, they actually are automatically by statute given statutory good time credit, again, for behavior purposes to make sure that for safety purposes and those type of things, that they have an opportunity to, as long as they behave while they're behind bars, that they'll actually get some type of good time credit. The offenses that are currently on the sentencing guidelines provide for 15 or 20%. This is a similar bill that passed out of House Corrections last year. The House Corrections had modified it previously to 25% good time credit for person felonies and 40% good time credit for non-person felonies. They also program credit also factors into this bill as well, in which currently individuals are allowed to receive up to 120 days of program credit. That is different programming that are provided within DOC, such as anger management, substance abuse treatment, vocational training, those type of things that are going to allow them to, they have to be intentional about going to get treatment and or take these classes to better themselves and get themselves potentially ready for reentry. This bill would increase that from 120 days that they would be eligible for up to 150. And you can see, again, the bed space savings here is significant. We provide a lot of incentives for folks while they're incarcerated, in prison. We don't provide that much incentive for folks to get off of probation. And so we are joining several of the states that have already done it for several years, but now we are looking towards incentivizing those folks to be successful on probation. This particular provision provides for discharge credit while they're on probation. It allows for a shortening of their probation term if they're in substantial compliance with the terms and conditions of their probation. It also allows for credit, 7 days of credit for each 30 days that they're actually compliant. So we're allowing those that are wanting to get off of probation and comply with the ability to actually receive. It is not a given by any means, and this would be an earned type of situation. But this too has a significant bed space impact. It is also a joint recommendation from the Reform Commission with the Sentencing Commission. One of the things that the Sentencing Commission has also looked at are the terms of probation. Currently, when you're placed on probation, you are looking anywhere from a term of 12 months to 24 to 36, and maybe in some cases up to 60 months in prison. This particular proposal will cap that at twice the term for each of those, depending on your sentence and the severity level. We already have a system that's set up that allows jurisdictions to, if you have monies that are still due and owing to the court for restitution, for the court to actually send that to collections. And those jurisdictions contract with collection agencies, and that actually is done in many jurisdictions. This would actually cap the probation so that that particular time they could either be revoked and sent to prison, or they could be either successfully terminated or unsuccessfully terminated And then if there are fines and costs, those would be sent to collections. One of the things that we were hearing from probation officers was just exactly the definition of not reporting and absconding. And absconding is a term of art that is used, and how do you determine that? The Supreme Court came out with the case in State versus Dooley that more readily defined what absconds from supervision is. We are simply asking that that be codified in statute to assist those probation and parole officers to better know when to actually determine whether or not an individual has absconded from their custody. Another joint recommendation from the Reform Commission that they're joining the Sentencing Commission in is we looked at the proportionality of those level 5 possession offenses that I talked about what seems like quite a while ago, and to determine whether or not the sentencing scheme is fair and equitable. And what we landed on was that simple drug possessions are proportional with severity level 8 non-drug crimes. And so what you'll see in this particular bill is a decrease in prison time for those offenders sentenced for possession, not for sale or distribution or manufacture, but those that are convicted of possession crimes. We do on the back end, for those that don't have as much criminal history, we've preserved the time or the sentence length for those in order for them to actually get adequate substance abuse treatment. One of the things that we took a hard look at, and this was with the assistance of Council for State Governments, was again, we know that every year the drugs are the largest cross section of or part of our criminal justice system, whether that be in convictions or whether that be in the need for treating folks with substance abuse that are abusing those substances. So we looked pretty hard at the drug grid to look to see what was happening. CSG was able to look at there are departures that actually occur on the drug grid on a routine basis, in which most of the time they're downward departures that are departing to probation, or they're even doing durational departures, which they're cutting the sentences quite a bit for plea deals. And so they analyzed the amount of departures that were actually occurring. We looked at what would look at from a realistic standpoint of how things could be changed to, again, not only provide for what's actually happening, because again, even though you see those months on the drug grid, it doesn't mean that those folks are necessarily getting that time. When prosecutors and defense attorneys make plea agreements, sometimes, again, some of the times that the folks are spending in prison or even getting sent to probation is significantly less than what's actually on the grid. And that's, again, by agreement. And if the court feels like that's necessary, then they can actually order that downward departure. So again, this is what it actually looks like. Again, this would expand presumptive probation to these particular grid boxes. It would add a border box to the 3 Gs. This is the bed space savings that you're looking at. This is a better indication as far as what the changes would be in terms of this entire level 5 would be presumptive probation. Now, that doesn't necessarily mean that they couldn't be sent to prison, but the presumption would attach that they actually would be presumptive probation and given a shot on probation before they, they certainly could potentially get revoked and sent to prison, but they originally would have that presumption. Some of the other, again, as I said, level 4s are small sales. This would be changing those current border boxes to probation. So they would be presumptive probation. 3 H's and I's. This is, for example, having, I think, like a gram of meth would get you a level 3. So this is, this again would allow for, if there were, keep in mind that there are certain circumstances that, both parties can file for departures. The court could do a departure if they wanted to. But in those situations, when there's a presumption that's attached, parties can always file motions for departure one way or the other. So this would significantly decrease prison population. It obviously would be at the same time would increase the probation population too. So for many of you that have been doing this for a while, you already know this, but anytime we start changing things like this, no matter whether it's on the diversion end, no matter whether it's on the parole or post-release supervision, there's push and pull that goes on within the system. And so the determinations have to be made. Is it more cost effective for us to imprison small sale drug dealers, or should we allow them to be on probation with potential treatment if they need it, with the idea that if they're not going to comply, they'll soon end up in prison? Or do we want to? Are we okay with just sending them to prison directly? Again, opportunity. And this particular one would be something that would give the legislature an opportunity to make a pretty significant difference in the drug grid. Again, following on the drug crime theme, one of the different recommendations, again, it's a huge bed space impact. But one of those is to look at drug offenders that are actually complying while they're incarcerated. These would be offenders. These don't include offenders that would be severity level 1 manufacture. It would be severity level 2 through 5 folks that have been directly sentenced to prison, and that after 50% of their sentence, they would be eligible to petition the Prisoner Review Board for release to community corrections probation. And so this is a little bit different than instead of going to post-release supervision, you would actually be availing yourselves to all of those services that probation has in a community corrections context. And so they would supervise them for a normal probation term, at which time that they are successful, then they actually receive that release time. And so then they would actually be they would be successful from their probation, and they'd be able to go on. They certainly, if they don't, they can always be revoked and sent back to prison. This just again allows for those folks that, and again, there would be a criteria that DOC through the PRB has, that they'll be looking at not just that you've done 50% of your sentence, but also there'll be public safety issues. There'll be other criteria that you have a plan as far as your release, those type of things, in which public safety is going to be paramount in terms of determining whether or not these folks can be released to the supervision of the community corrections. We again will join the Judicial Council as far as asking the legislature to modify the Kansas Offender Registration Act. This is our particular proposal will again center on removing drug offenders from the registration. There are many reasons for that, and that's something that we can get into later on. But Judicial Council has many other recommendations as far as reduction of penalties, as well as reporting requirements, that are all well-reasoned. They've been at this for a couple of years now. The chair has actually served on that committee as well as others. And so they've spent a lot of time on this. This commission has spent a lot of time on this as well, and know that the registries do not work. That's the simple long and short of it. There is no research that supports the use of registries. Kansas is one of the few states that even use drug offender registries. Just a handful of states that actually have decided to do it. There are no federal requirements to actually use it. So we'll be bringing that one again. And I'm finishing up here. I appreciate all of your attention up to this point. The next two are more technical as far as sentencing rules are concerned. I know you wanted to hear that. They're more technical in nature, but they have arisen as a result of trying to clarify some of these particular statutes. And the first one has to do with what a court can do if an individual is on bond and they commit a new felony. What happens to them? We're asking that the court be allowed the discretion, depending on the circumstances, to run those sentences consecutive or concurrent and leave it up to the judge. The next one has to do with Special Rule 26 and Special Rule 12, Sentencing Rule 12. This has just cleanup language as far as language in terms of prior convictions and how they're actually applied at sentencing. That's something that hopefully we'll be able to get into. Both of these sentencing rules are written in such a way that is not consistent with some of the other sentencing rules, and so we're just asking that to be consistent as far as the language is concerned. This is a big one. This is something that has been talked about within the Sentencing Commission for over a decade, and we're finally bringing it to you in that we know and have known, and most folks know that who are practitioners in the system know that just because I'm convicted of a theft or a burglary doesn't mean that there aren't any underlying substance abuse issues. What we're asking in this particular proposal is to utilize Senate Bill 123 funding for non-drug offenders at sentencing. And this would be those individuals that were convicted of a level 7 through 10, which are lower felonies, less serious of felonies that are non-person felonies. And so many of those, certainly, as many of you know, are convicted and sentenced because they're trying to get money to support their habit. And so this would allow for again, as you know, there would be a fiscal note on this, somewhere in the neighborhood of what we're estimating anywhere from about $750,000 to $2.2 million, depending on the number that would be sentenced. But the obvious is there, and realistically, we know that those individuals would also benefit from state paid treatment. This is also a Senate Bill 123 proposal. It simply is more procedural in nature. A lot of times right now, individuals that are placed on Senate Bill 123 may have committed their offenses. I'll use Harvey County, for example. They go and commit their offense in Harvey County, but they live in Johnson County. And so they go back to Johnson County after their case is over with, and they get courtesy supervision from a probation officer in Johnson County. If they have some type of a revocation that they don't comply with their supervision terms, they have to go all the way back to Harvey County to have a judge decide whether to revoke them or not. This particular provision on Senate Bill 123 cases only, where there normally, if not ever, is any victims in the case, this would actually allow the court on with the agreement of all the parties, the sending and the receiving jurisdiction, would allow them to transfer the case in its entirety to that place where the individual is residing, the offender is residing. We think it's going to be more, it would streamline the process, and it allows for the receiving jurisdiction to essentially be able to decide, their community values in terms of, since this individual is living there, violated there, that they should be able to allow the local jurisdiction to manage the public safety aspect of that. And again, this would be one of those discretionary things that both sending and receiving parties would have to agree to it, or it wouldn't happen. Finally, we have, again, more of a housekeeping type of setting. What we've seen over the years and what we're recommending is, while we appreciate the Senate and House leadership that comes to bear as far as, or is brought to bear on the commission, and we are very grateful for all of the members that have served there. What we've seen in the past is that those individuals that serve or are serving on Senate Judiciary as well as House Corrections and Juvenile Justice are very engaged with what's happening, and they wouldn't be if they weren't interested in being on those committees. So what we're suggesting or proposing is we're asking that the Senate and House leadership make those appointments to the Sentencing Commission from members that are in those committees. And we believe that we will get even better products to you as a result of that. So with that, thank you so much for the opportunity to address this committee. I'm looking very much forward. Obviously, the commission has quite a few bills that they have introduced. I'm looking forward to being able to share our hopeful vision with you, that you're willing to look at that and feel that it is the best thing for Kansas. And at this time, again, ask you to remember that we are in a situation, unlikely situation, that's been beneficial as far as bed space is concerned due to a horrible pandemic. But we are at a time where we have an opportunity, and these proposals will be able to provide Kansas with an opportunity to continue to be under capacity. And with that, I'd stand for questions.
Scott, thank you very much. Thank you for the work that your staff and you do, and all of the data gathering and information that you provide. I would mention to the committee just a couple quick things. The bed space impact statements that Scott's group provides to us as an attachment to bills will be placed on the website, along with the testimony that would be provided on any bills, and that will be available to you that way. We do not contemplate printing those up and handing them out, working towards that. Scott, I would ask that you maybe prepare and deliver to members of the committee the sentencing guideline charts that you customarily bring by. They're very nice color ones, so that people can have that more as a desk reference. And the last thing that I would say to committee before questions, all of the bill proposals that Scott has visited about this afternoon, we will have plenty of time at a future date to discuss those in detail. And I would ask that you refrain from questions about those recommendations until we have hearings on those bills and those proponents and opponents have an opportunity to appear before the committee before they're considered. That I know that I have Representative Carmichael wanting to ask a couple questions. If you have questions, please raise your hand and I'll look at the participant list to get that. Thank you. Representative Carmichael.
Thank you, Mr. Chairman. Mr. Schultz, I do have 3 questions this afternoon. The first one concerns, I believe it was your second slide. It made reference to the guidelines desk reference manual, the Sentencing Guidelines Desk Reference Manual, otherwise known as the DRM. I was unfamiliar with that publication. Is it available online, or how can we secure a paper copy if not?
Representative Carmichael, thank you for the question. Yes, the desk reference manual is available in an online capacity. However, the commission routinely will provide those hard copy desk reference manuals. We will get a copy to each member of the committee, as well as the laminates, which are the grids, both the drug and the non-drug grid to all of you.
It would also be helpful if you could let us know where to find it online now that we're moving into the 21st century very slowly. My second question, I don't think you'll have the answer for, but perhaps you can help me look for where to find the answer. There's great concern right now with the number of folks who have been charged but have not yet been tried. Some of those folks are in pretrial detention. Many of those folks are on pretrial release. I recognize you're on the back end, you're the Sentencing Commission. Is there any source or way that you know of that we can get a handle on what this backlog of folks who are either in pretrial detention or on pretrial release, how many people we're talking about? Is there a source or a way for us to get a handle on that?
Representative, I do not know. My first thought would be the Prosecutors Association might be able to pull together. I don't want to give them more work, but they may be able to know their backlogs as far as their case management systems. It may be a piecemeal case, jurisdiction by jurisdiction situation, but I don't know of any other entity that would be able to track something like that.
And Mr. Schultz, I recognize that's outside your area of responsibility. I thought it might just help us figure that one out. My third question is a hypothetical one. Let's just presume that there was some wild-eyed liberal representative from Wichita who one day got the crazy idea that what we ought to do is that we ought to turn everybody loose from prison who's in prison on account of possession, sale, or use of marijuana. Give them all clemency, and revoke all of the marijuana prohibitions in the law going into the future. My presumption is that would have an immediate bed impact, and it would have an impact on your projections going forward of bed space. Is that type of information something that's available directly online through your database, or if a foolish representative from Wichita were to propose such legislation, would he or she need to contact you? How do legislators go about getting some idea about bed space impact when they're just considering legislation before actually being so foolish as to provide amnesty for marijuana?
Representative, hypothetically, I would say that you are welcome to contact our office. We are, and I apologize, I should have said that from the outset. This commission is available to legislators to ask for ad hoc information at any time, and we have done suggestions, hypothetical suggestions like that as far as marijuana is concerned. We need only get together by phone, Zoom, or email, and we can actually work on that. Even if you have an idea such as that, before you want to file it, to get some idea of what kind of significance or insignificance it may have on the population.
Well, Mr. Schultz, I want to assure you that was merely a pipe dream on my part. I appreciate the very comprehensive and well-organized presentation today. Thank you, sir. Thank you, Mr. Chairman.
Thank you, Representative. Any other questions for Mr. Schultz at this time? I see no hands on the participant list. If you wish to ask a question, speak up, or forever hold your peace. Or at least for today, hold your peace.
Well then, Mr. Chairman, one additional question with your permission.
Quick one.
Is it the Commission's intention to throw John Barker off the Sentencing Commission through the legislation that you propose? I'll withdraw the question. I'm sorry, Mr. Chairman.
Thank you, Representative. Scott, once again, thank you so much for a great presentation. We appreciate your work, that of your staff. Committee, we will be meeting Tuesday. That will be a hybrid meeting. You're welcome to join in the committee room or online. I would just say to you that we got through about 90% of our time today with some level of success with technology, but much of what's supposed to be working in this committee room is not yet working correctly. And we may have to adjust on the fly. I hope you understand that. But we will have a hearing on a bill on Tuesday. It's on the agenda that's posted. With that, I would say that this meeting will be adjourned. And if I don't see you until next week, I wish you a safe travels home and a good weekend.